Welcome to the Generis Show, your unique perspective on everything you need to know about your civil rights and the criminal injustice system. With Erica Merrill, I'm attorney Brian Jones, criminal defense and civil rights warrior. Today in segment one, we'll be catching up with developments in the prosecution of Danny Masterson in California State Court. We're going to be looking at a recent decision by the Supreme Court of the United States granting states the right to put children in prison forever. And we're going to discuss how 3 cities in the United States of America have changed policing in the aftermath of the murder of George Floyd. In segment 2, as promised, we'll be exploring the relationship between Ohio's implied consent laws and the administrative license suspensions that result from violating them. To make sure you don't miss an episode, subscribe on Apple Podcasts, Spotify, and YouTube. Follow us on all of our social media channels and look to the law office of brianjones.com for everything you need to know about your civil rights and the criminal injustice system. So Erica, did you see in the news this week that Danny Masterson's preliminary hearing went forward and the judge found probable cause to make him stand trial on the rape allegations by 3 individuals?
Yes, I did. And I have to say that this is such an interesting case. I can't wait to find out how all of this unravels. So can you tell us, how did the judge reach this decision?
Well, so the judge listened to evidence at what's called a preliminary hearing. And in this situation, the prosecutor has to present sufficient evidence to determine if there's probable cause. It's kind of a threshold question before we get to proof beyond a reasonable doubt at a real trial, at a full jury trial. Now, recall that these accusations are more than 20 years old, and they come loaded with circumstances, exactly as you were talking about, that all the parties in this case, the accusers and Mr. Masterson, are members or ex-members of the Church of Scientology. Now, the defense provided significant cross-examination and ultimately decided not to put on any evidence of their own. And based on that information, the evidence presented by the prosecution, the judge determined that there was sufficient probable cause to proceed through the California criminal justice process. And so the next stage will be either presentation to a grand jury for indictment or an information, and that's in the prosecution's discretion.
You hear about this preliminary hearing, and I just wondered, can you explain how this works in the state of Ohio?
Very differently from how it works in the state of California, Erica. So in California, the preliminary hearing stage is a level at which a case can get bounced out of the criminal justice system completely. But here in Ohio, it's more of a determination as to whether somebody can be held in jail pending resolution of their case. So under Criminal Rule 5, which outlines the timing and the requirements for a preliminary hearing in Ohio, the preliminary hearing has to happen within 10 days of arrest for those people that are unable to make bond, and within 15 days of arrest for those who are out of custody. Now, an accused person can demand their preliminary hearing, or they can waive that. And that decision really needs to be made with consultation with a defense attorney, because the preliminary hearing is a valuable opportunity for the defense to get a sneak peek at the prosecution's case. Now, the government or the prosecution or the state has the burden of producing evidence at the preliminary hearing. And the accused has the full right of cross-examination and the right to see any exhibits that the government is going to use before the hearing goes forward. Now, after the state presents its case and the defense gets to cross-examine all of its witnesses, the accused person can ask the court to dismiss the charges or decide if the defense wants to put on evidence of their own to try and convince the judge to dismiss charges. Now, in this situation, any evidence that is presented now becomes part of the record and can be used at a later trial if the government decides it's helpful to them. Ultimately, in Ohio, the judge has to decide if there's probable cause, and that's a reasonable belief to hold the 3, 2, 1. Now, ultimately, the judge will decide if there's probable cause to believe that a crime has been committed and will either order the accused discharged, meaning the charges are gone and dismissed, or order the accused to be bound over and the case taken over to the Court of Common Pleas if the finding is for a felony. Now, even if the case is dismissed at this stage, the prosecution still gets a second bite at that apple by presenting their case to a grand jury.
Wow, that is really interesting to hear what the differences are between California's preliminary hearing and Ohio's. And it sounds like there's plenty of chances for people to state their case. And so I think that's a great way to do it. So can you tell us what is the standard of evidence in a preliminary hearing?
Ohio uses a substantial credible evidence standard for the judge to decide whether there's probable cause at a preliminary hearing. So substantial credible evidence is evidence that a reasonable person might accept as an adequate quantum of proof to support a conclusion. It's more than a scintilla of evidence, but it's less than a preponderance, that 50-50 standard that we use in civil cases.
So is it weird that they waived the opportunity to present evidence for the defense in this case?
I don't think that that's really out of the norm in a situation like this, primarily because this is a situation where the standard of proof is so low that it's very likely that the plaintiff, the prosecution, the government of California in this case, is going to be able to meet that burden regardless of what evidence you put on. Frequently, the defense is putting on evidence explaining situations. It's very difficult to prove that something didn't happen. And that's why, we have the standard proof beyond a reasonable doubt in a criminal case. And B, in this sort of situation, the prosecution has a very low bar to step across. It's just, is there some evidence to allow this to go forward into the more complex aspects of formal litigation and ultimately ending up in a jury trial?
It's really interesting. And then you and I had quite an interesting conversation before we started this interview on the effects of Scientology on this case. And I just wondered if you think that it's going to have any effect on the outcome, and if you think that this is in fact revenge from the people accusing Billy Masterson.
Erica, I think that's a really interesting take on this particular situation. And in fact, during the course of the case, the judge had to admonish the prosecution that Scientology was not on trial. Scientology was not a named defendant in this case. So it sounds like the accusers have not only an axe to grind against Danny Masterson, but against Scientology as well. So I think we're going to be watching and looking at that angle. Remember, in these sorts of sexual assault allegation cases, what we're frequently looking for is motive to fabricate. We live in this Me Too era now. And so the default of society, of populations, is to believe the accusers. And if that's the way that people are going to start, not with the presumption of innocence, not with the constitutional principles that our nation was founded upon, but we're going to start by believing the accuser, then what's really important is the defense present that motive to fabricate, that motive and reason why these are lies rather than the truth.
Well, thank you so much for answering that question, because I really think that people, they get interested in these types of cases when there's someone famous involved, and right or wrong, this is in the news now, and it just has so many interesting sides to it. I'm so glad that we have you to walk us through this labyrinth that this case seems to be, and I know that we'll be talking about this again in the future as the case progresses.
Absolutely. We're going to keep a close eye on this case as it not only touches on our wheelhouse of sexual assault defense, but the various intricacies and unique aspects of this case, from the 20-year delay to the Scientology angle. We're definitely going to keep a close eye on the progress of this one. Another thing that we keep a close eye on here at the Law Office of Brian Jones is the Supreme Court of the United States. And recently, Erica, they released a decision making it easier to put children in prison for all of their lives, ignoring known science about childhood development. Did you see this sad story in the news this week, Erica?
I'm just shocked because I think anyone you talk to that knows kids know that they think differently than adults, that have all their mental faculties. It's just amazing. So how is neuroscience connected to the issue of juvenile incarceration?
Well, neuroscience has identified the prefrontal cortex as the part of the brain that's critical for complex reasoning and managing impulse control and instincts. Now, our prefrontal cortex enables our brain to set priorities, form strategies, manage that impulse control, and envision the future, plan for it, consider the consequences of our actions today on that future, and stop us from doing things that are going to have those negative consequences. The thing is, in a teenager's or a younger person's prefrontal cortex, there isn't that ability developed yet. It's not fully matured. The adolescent brain is different in anatomy, in its shape. It's different in its chemistry, and it's different in its physiology, the way that it works. It is an established medical fact that has been used to argue against the death penalty, against life sentences, and against life without parole for juveniles successfully in front of the Supreme Court for decades. So neuroscience has been used for decades to understand why children make the choices that they do and limit the consequences to those that are appropriate for individuals that have the deficiencies that children have.
That makes a lot of sense. And I mean, there's a reason that neuroscience has been at the forefront when you are trying to figure out what makes people tick. And so that can go for any age person. And I've heard before that this is why kids make quick decisions, they anger quickly. I swear to God, it feels like a roller coaster sometimes with my 8-year-old. We're doing great, and then all of a sudden she's screaming at me and I didn't even do anything. So I calmly point that out and I make her apologize. So I can absolutely see why some of these kids are making split-second decisions and not thinking about the consequences lately. I'm not sure why the Supreme Court doesn't see that. I mean, I'm sure they all have kids too. Let's talk about, what are the details around this controversial decision, and why did they go this way?
So the decision in Jones versus Mississippi makes it easier for state courts to sentence children to life in prison with no chance of parole, finding that the Eighth Amendment doesn't require a finding that a juvenile is quote unquote permanently incorrigible before imposing that life without the possibility of parole sentence. So that's how they reached their decision. After 15 years of decisions that have placed more and more limits on sentences that are imposed upon juvenile offenders, the court has reversed course, abandoning precedent and making it that much easier to put children in prison for the entirety of their lives. The Supreme Court has adopted this perspective that the early teen years, and this is a quote from the case, cast the die on children, and that once this course of action has been started, it can't be stopped or changed. What the Supreme Court is essentially saying with this is that the way that a child is at the age of 13, 14, 15, 16, 17 years old is how they're going to be for the rest of their lives, which is not only contrary to science, but it's contrary to common sense. The executive functioning processes of the brain, primarily related to impulse control, planning ahead, and risk avoidance, are not fully mature in these key regions and systems of the brain. That's what science tells us. What common sense tells us is that 15-year-old little Billy doesn't make quite as good a choices as 25-year-old Billy. And that's the reason that we don't let 12-year-olds drive cars.
Right? Or drink, or it's just a lot of things that, or vote. There's a lot of things they can't do until they are fully developed.
It's precisely the issue. And the Supreme Court has decided we are not going to listen to science any longer. We are going to take a retribution style position when it comes to the criminal injustice system. And Erica, I think this is a harbinger of some terrifying decisions that are going to be coming out of this court over the next 5 to 10 years.
Yeah, sadly, I have to agree with you.
But the good news is, Erica, that at the local level, significant positive change is being made. Did you see the story on Vox about Austin, Texas, Portland, Oregon, and Minneapolis reimagining policing after the murder of George Floyd?
Yeah, I did. And I am really happy to see that's happening. Actually, my father just moved near Austin. He moved to Fredericksburg. So it's something that I look at now when I'm looking at the news of that area and what's happening over there. So can you tell us your take on the changes that Austin, Texas is making?
So Austin cut their policing budget by a third, leading the way among 20 of the United States' largest cities that have reduced police budgets for 2021. And what they did was they took that money and they've used it to fund organizations that are aimed at decreasing the need for police, funding civilian oversight of the police, and making agencies like the 911 call center and the forensics laboratory independent of the policing department. So we're taking the people that take the calls and the people that analyze the evidence, and we're making so they don't have skin in the game, so they can make more objective, accurate, evidence-based decisions in their progressions. You know, it's been really difficult, and allocating funds has taken time to distribute, and there's been a lot of criticism both for the slow speed which these funds are getting rolled out and the lack of focus on the homeless population, particularly there in Austin. But city representatives and activists say that the Reimagining Public Safety Task Force has come up with an excellent plan of recommendations that includes providing services to those who have been affected by violence. So an area that the police have never dipped their toe in is now getting some positive flow of money, making changes to police training so that they can do a better job and better serve their community, be safer police officers, increasing staffing levels in a variety of key areas for the police, and changing patrol practices to make it more effective and make police safer. So this is, again, it's one of those dual efforts. People hear that phrase, defund the police, and it's immediately this red or this black or white, on or off switch based on what your political bent is. But the reality is so much different. The reality is that it's making police safer. It's making their job easier. It's giving them resources so that they can do what they're supposed to do, which is keep us safe from the really violent criminals. And it expands community engagement so that their job becomes easier in investigating crime and the people actually want to participate and help them. Now, it's not been a light switch, and it's not going to happen overnight, but Austin is now engaged in that slow and arduous work of codifying and funding these reforms. So, Austin's changes have been, they've been slow to roll out, but the vision is there. And I think that Austin is an excellent example of the breadth that these sorts of changes can take on and the assistance that they can give to local law enforcement.
And I'm glad that you're pointing that out, because it is often thought of as a punishment to the police, because all of this started happening after there was so much news on cases like George Floyd. And we just had the anniversary of George Floyd's death this week, which is very sad. But this is all the changes coming up, and I see it as positive as well. And I hope that someday everybody else does too, on the police forces and those that support them, because we support them as well. And so we appreciate what they do, and definitely just want to make it easier. Put the right butts in the right seats, as they say.
Absolutely, Erica. It's all about finding the right people with the right specializations to do the job properly. And that's the foundational principle of this defund the police movement. And Austin is really setting the example.
What can we learn from the changes to policing made by Portland, Oregon?
So Portland voters were the catalyst for the change that we see in Portland back in November of 2020. They really took to the polls and made some significant modifications to what was one of the country's most progressive police oversight systems. Now, that police oversight system is one of the country's most powerful. So they've replaced their current citizen review committee with an expanded and more powerful board that's going to go beyond just receiving complaints and processing appeals. The new board is going to have the power to investigate misconduct. They're going to be able to subpoena documents and compel the release of evidence. They're going to be able to take testimony, and hopefully they're going to get buy-in from the police and use the cooperation of police officers. Now, the new board will also be able to set policy for the police. And if the policy is rejected by the police department, then the policy is going to be sent to the city council for a vote. So the citizens are going to have control over how they are policed. And if the police don't like their recommendations, then it's going to go to the city council. It's going to go to the legislature for a vote. Erica, this is really the way the government is supposed to work. The police are the executive branch. The city council is the legislative branch, which takes its commands from the people, the most democratic aspect of our government. And then the judiciary will absolutely be brought in to settle the disputes between those two. Now, the current projections put the board at fully functioning in 18 months. And of course, once again, the police union is fighting hard to prevent the implementation of these reforms. The more power boards who oversee policing have, the harder the police unions are going to fight it, which, Erica, is really counterintuitive, because what we see time and time again is that these reforms are made, police jobs become easier, policing becomes more effective, and the safety of officers goes through the roof.
And I think that's amazing. It's exactly what we want to happen. So let's look at the last major city that we're talking about today that have made some changes, Minneapolis. Are there reforms in Minneapolis that you hope to see in Central Ohio?
Yes, Erica, I think there are some reforms that Minneapolis has implemented that could be used here in Central Ohio and really across the nation. So while the reforms out of Portland were citizen driven, Minneapolis City Council, the legislature, really drove the reforms that we see in the Twin Cities. Now, the city council unanimously passed a resolution laying out a plan to spend 1 year just engaging with the community, researching and implementing structural change to create this new model. So what Minneapolis has decided to do is get feedback, and get feedback in a scientifically reliable way. Now, Minneapolis has also been able to change the department's use of force policy immediately, but it hasn't been able to make any progress on dismantling the police because of the language in the city charter requiring the police force to be based on city population. So we can also look in this region to the city of Brooklyn Center, Minnesota, which is a suburb. And they recently voted to create a community response department that's tasked with taking all of the calls related to medical, mental health, disability related, and behavioral and social need calls. Now, I think this particular reform is probably the single most valuable defunding the police reform that the entire nation should implement. There's zero reason for law enforcement to be marked out, called out for medical emergencies. There's no reason for them to be called out for mental health emergencies. There are appropriate and properly trained individuals that can go out to these calls, de-escalate them properly, where everybody can be more safe. And again, taking the burden off of the police. And I think this is the number one reform that I would like to see in Central Ohio.
Yeah, I think things are going to work a lot better that way. And I'm really interested to see how it does roll out in Central Ohio. I mean, when do you think that this is going to happen? When do you think some of these reforms are going to really hit here? I know you've got a few already.
So Columbus Police is still looking at hiring a new chief of police, but I expect once that chief is installed, we are going to have a domino effect of reforms coming along. Columbus Police, as you know, as progressive of a city as Columbus is, Columbus Police has one of the worst reputations right now in the country for being excessively violent, for shooting its citizens over and over again. So I think this is an area that is ripe for reform. And I hope this reform is one of the first that we see.
Me too. And I know that we'll be staying on top of these changes as they get rolled out.
For sure. We're going to keep an eye out. And as Columbus reforms and as cities across the nation change the way that they police their citizens, we're going to be here to bring that news to our listeners. Today, we're going to bring news and information about implied consent. Now, implied consent is consent, agreement, which isn't expressly granted by a person, but it's rather granted by a person's actions or the facts and circumstances of a particular moment in time. So when you accept your license to drive in Ohio, you have implicitly consented to submit to a chemical sample upon request from a law enforcement agency. And if you refuse, that police officer can yank your license and suspend it immediately for his belief or her belief that you've been involved in a DUI.
Is really interesting. I cannot wait to hear what you have to say about implied consent and administrative license suspension. Say that 10 times fast.
that.
Well, that was really good.
Thanks.
Now try it with administrative license suspension. So what's the relationship between those two?
So Ohio's implied consent law is in 4511-191. And what it says is that anybody who's in control of a vehicle shall be deemed to have given consent to a chemical test of that person's blood, breath, or urine if there's probable cause to arrest them for an OVI. So in other words, if you're out on the road operating a car, the law assumes that you're going to submit a chemical sample if you're arrested on suspicion of OVI. Now, this is true even if you're unconscious and you can't refuse the chemical test. So you get in an accident, you're taken to the hospital, you're unconscious. The officer is allowed to take your bodily fluids without ever talking to you because you've accepted a driver's license in the state of Ohio. Because the law assumes that you agree, if you revoke that consent, if you decide that you're not going to agree, it can take your license away from you, and it can use that refusal against you throughout the remainder of the court process. In fact, if you refuse a test, the law allows the officer to use any reasonable means necessary to ensure that you do submit a chemical sample, all the way through sticking a needle in your arm and forcing blood into a vial.
That sounds crazy. That sounds like aliens just abducted you and they're doing all these crazy tests to you. I mean, I'm shocked by it, but and I can kind of guess the answer to this next question I have for you, but why is it important that implied consent is triggered after an arrest? Because they're stacking the deck in their favor, I'm sure, but go ahead.
Well, that's the little bit of protection that we get, right? Because if the officer doesn't have probable cause, then the officer can't arrest you. And if the officer does arrest you without probable cause, that officer has now committed a Fourth Amendment violation. So you get the protection of the exclusionary rule. The evidence is thrown out and they can't prosecute you with it. And you have the potential for a civil lawsuit if you can get past qualified immunity. And we've discussed how difficult that is. But the implied consent is really more about what you must do and a lot less about what you need not do. Now, what you need not do is submit to field sobriety tests. Implied consent does not mean you agree to do field sobriety tests because field sobriety tests come before arrest. Implied consent does not mean that you have to make any admissions or any statements because again, these happen before arrest. So if the officer comes up and says, how many have you had tonight? I know you've been drinking, just admit it. You don't have to talk to him and he can't take your license if you refuse to do so. But it's not a protection for a person that's already been arrested. It's a trap, and it magnifies punishment on the basis of a policy belief that it's more important to catch, punish, and rehabilitate drivers than it is to provide safety and bodily autonomy to those who choose to drive on public roadways.
Wow, it's worse than I thought. That's very interesting. And that's why it's really important that people understand that even though police officers have a position of authority, you do have the right to say no when it comes to field sobriety tests. And all of those tests are just going to be stacked against you, whether you have had drinks or not, in many cases. So this is really interesting to see how implied consent adds another layer on top of that advantage that they have, along with being authority figures that people just listen to every single thing that they say.
Oh, absolutely. And when we talk about urine and blood samples, particularly, how is the government handling those chemical samples after they're done with them? Is that chemical sample going to be turned over to an insurance company that's then going to increase your premiums because of some genetic condition that you're predisposed to? Are those samples going to be kept in a secure location? Could somebody go and steal this information from the government? We have no idea how these samples are treated and if they're being treated appropriately. And this is why we don't give that information to the government, because you don't know what's going to happen with it down the road.
I wish everybody listened to your show because this information is not widely known. And it's not one of those things that you would assume. So honestly, the information that you disperse on the show really saves lives in the long run when you think about careers, families, and reputation. So why should an accused driver refuse a chemical test if a refusal could mean additional sanctions down the road?
Erica, that's a great question. And it really is a catch-22 because if you submit to the chemical sample, You can be charged not only with an impaired OVI, the observations of the officer, but you can also be charged with a per se OVI. Your chemical sample had a level over a number set by the legislature. Your license will be placed under an administrative suspension if you test over, and that whole process of defending yourself against false allegations becomes that much more difficult. Now, if you refuse to participate in the testing and no warrant is sought for your blood, then you can be charged with the OVI impaired, and you're going to face increased consequences because of your refusal. Your license will be immediately suspended and suspended for an even longer period of time. So while a refusal may come with higher sanctions at the outset, it does provide you greater protection from illegal, unlawful prosecution because you're not participating in the process of creating false evidence against yourself. Remember that OVIs in Ohio are strict liability crimes for which the punishments have been designed by the legislature to increase in harshness over and over again intentionally due to the limited discretion of the sentencing courts that impose the consequences for OVI in this state. So what that means is that your consequences get higher and higher and higher over the course of your life if you get accused of these crimes in the future. And courts can't take into consideration your particular circumstances. That discretion has been taken away. That choice has been taken away from the courts by the legislature.
Well, it's disturbing. All of this information is disturbing. And that's why it's important that you have a great criminal defense attorney if you get pulled over, because you may or may not have heard this podcast. You may or may not have refused these roadside tests, and you might need help fighting those results later on. And so if you are in the area of Central Ohio, absolutely give the office of Brian Jones a call, because they keep up on all of the changes in the law, and they have fantastic strategies to help fight for your rights and make sure that this is an even playing field.
Thank you for those kind words, Erica, and thank you for joining me today. And everybody out there who listened to our show today and all the other times you've listened to our show, I thank you as well. To stay informed about the latest developments in the most interesting cases in courts across the United States, holding police and government accountable for their misdeeds, and everything you need to know about administrative license suspensions, OVI allegations, and that whole process, look to the Law Office of Brian Jones at our website, thelawofficeofbrianjones.com. Find us on Facebook, facebook.com/Central Ohio Criminal Defense, and find us on Instagram, TikTok, and Twitter at TLOBJ. We'll be back next week with a sui generis perspective on the next hot topics in criminal defense and in civil rights and criminal injustice system news, as well as a discussion into the research of false allegations of sexual assault and how frequently that happens. Erica, my grandfather always told me when we parted ways, hey kid, don't do anything I wouldn't do. And to that, I add when I separate from my friends today, if you do and you get caught, call me. I'll defend your rights as I'd want mine defended.